His attorney at law, Joseph Joey Torts Ferretti. He joins us via telephone. Joe, good morning.
Good morning, gentlemen.
You remained remarkably quiet there while Bill was getting abused this morning.
Yeah. Where were you, Joe, for the first 30 minutes?
Yeah, acting against all impulse to jump in and abuse him.
Yeah, I was going to say, I'm not sure if I wanted you or not. I thought I could depend upon John Gilstrap. Found out I could not. It may be the same thing with Joe Ferretti. I might find out I could not depend on him either. So.
This all started.
You know, Bill, we love you, Bill.
This all started Sunday night. So I take a screenshot of the guests and send it to the co-hosts at some point. Sometimes I forget, and when I do, they'll text me and say, hey, what's going on with the guests? So Friday before I left, I thought, well, this will make, for an easy weekend for the guys, I will send out the guest shot. So I sent the guests out. It was actually Friday at 1:11, according to my phone. I get a text last night from Bill. Who are the guests? Why aren't you sending these out? Where are the guests for Friday? And then John sent a screenshot of the Friday guest shot that I'd sent out to Bill. In the meantime, I sent Bill a text that said, Bill, I sent it out Friday afternoon. If you scroll up, you'll see what the calendar is for today. Well, Bill came in guns blazing here this morning.
Well, the tone of your note was
snarky.
Bill, you moron. That was a silent part. So there was some snark.
See, I think you just switched teams there, Gilstrap.
Hey, I'm the interlocutor. I'm on neither side.
That's what I think just happened. I said, Bill, here's the exact words. Bill, if you scroll up past the Danny updates, you will see that I was actually on my game and had sent it out Friday at 1:11 p.m. Now, Joe, is there anything offensive in that?
That's not the version I received, Joe.
It is the exact version of what you received.
No, there's nothing offensive about it. I understand.
Come on, Ferretti.
I always check texts from Rob consistently, wanting to know who the guests are, and if it was if I didn't know the guests, it was my fault.
Yes.
Gotta be.
Yes.
Gilstrap and Ferretti. I don't have any friends, any supporters.
So that was a showstopper.
I'm just laughing so hard over here, I can't talk. Joe, we had a lot of decisions by the Supreme Court Friday, and I think they sent out 6 of those. And correct me if I'm wrong, but these are the last decisions for the summer. They don't hear anything else again until, is it October, Joe?
Well, there's always an emergency docket where an individual justice is designated to sit and hear cases if necessary, oftentimes on brief, oftentimes on an emergency basis with opinions that are issued that are not what we're used to and resolving a lot of the important constitutional issues. So the court is never officially not working, but yeah, this is the summer recess, and the end of June is when these last opinions typically tumble out of the court, and some of them, as usual, have pretty wide implications for the nation.
When will they resume as a full-time court hearing cases? Is that September, October timeframe?
October.
First day in October. First Monday in October.
Yep.
Yeah. Which is it, John? First Monday or first day?
First Monday. It is. Unless, well, it's both. If the first day of October is,
Bill laughing over there.
On Monday.
You've been set up, John.
Okay, Joe, let's tackle some of the bigger decisions. And you can lead off. I know there were 3 you wanted to highlight. Lead off with the one you'd like to talk about most.
Yeah, of course, the birthright citizenship case was on everybody's mind here at the end of last week. And somewhat, a little disappointing if you wanted the issue of birthright citizenship, which is embodied in the 14th Amendment, if you wanted that resolved. That did not happen. As the arguments revealed when the case was presented to the court, the issue really was the injunctions that lower district courts were granting that had nationwide effect. Now, what got us here, remember, Trump's executive order banned birthright citizenship, which meant that babies born from parents who were not citizens themselves. This is precedent and went back. Birthright citizenship goes back to the 1860s. And the courts have consistently upheld the notion that if you're born in this country, you're a citizen. Well, the Trump administration wanted to end that practice, and so an executive order was issued. The case started in the district court level, of course, and the district court decided that while the birthright citizenship issue is something that affects everybody nationwide, so we're going to stay everything. We're going to stay the president's executive order, and they granted this nationwide injunction. And that was the issue that was brought forth by the Trump administration to the Supreme Court. Can these district courts grant these nationwide injunctions? And what the Supreme Court decided in Trump versus Casa Incorporated et al., it decided that the lower courts no longer had the power to grant nationwide injunctions whenever they were addressing constitutional issues or matters of federal law. It was a 6-3 decision. Amy Coney Barrett was the author of the decision, and she took the tack of arguing originalism, which is looking back in time to what the founding fathers said or would have done with this issue. And what she said was basically the founding fathers never envisioned a lowly district court judge operating in a way where their decisions would be applied or have effect nationwide. So what we're left with now is a situation where in almost all instances, there's very few exceptions, but in almost all instances, when a federal district judge issues a ruling, that judge will not have the ability to bind other states or bind everybody across the country. So we're going to have, I think, at risk here, a little bit of a patchwork of decisions. And ultimately, the Supreme Court is going to be deciding many of these. And if necessary, the Supreme Court can grant a nationwide injunction if there's an important constitutional principle at play. But really, the onus is going to be on the Supreme Court to take up some of these cases in an expeditious way and try to decide them before too much chaos ensues. Because, for example, in birthright citizenship, it's conceivable now that we could have various states that grant such citizenship to people born in this country and other states that do not. And you can imagine all of the implications for that in terms of getting qualifying for Medicaid and other federal benefits. We're going to have a patchwork of laws that are going to be hard to manage.
But do you think this was ever really about birthright citizenship? Wasn't this really about the district court decisions that have been stymieing
absolutely, John.
Trump's entire program?
And in fact, John, the Biden administration, the Obama administration, and those preceding Trump also argued that sometimes the preclusive effect of these lower court decisions were stymieing the efforts of the administration itself to execute the laws. And so this has been an ongoing problem or an issue for 20 years. And it was leading to judge shopping and forum shopping by litigants trying to get in front of certain judges to get the decision they wanted and have that decision apply nationally. So there was a problem here to solve. Whether this is the best solution can be debated. I think Congress could have stepped in and done some things to perhaps deal with forum shopping and judge shopping. But this has been an ongoing issue for quite a while, and that was what the Trump administration really wanted to push in front of this Supreme Court, was the effect of these injunctions.
And you may well be right on that, Joe, but I think that the birthright citizenship was something that many folks thought would be addressed. And I heard the Attorney General under the second Bush administration said he thought they came to the procedural issue as opposed to constitutional issue is because they could not get to 5 for a determinant on the constitutional issue of a birthright.
Yeah, I saw that comment. That was from
Gonzalez.
George Bush's former AG. That's a little speculative. I thought in the arguments where the substantive matter of birthright citizenship was being discussed before the U.S. Supreme Court, I thought that there was enough resistance there to anticipate that they'll strike down the executive order eventually. because it's a plain reading of the 14th Amendment of the Constitution. It takes a little bit of a strained argument to say that doesn't grant birthright citizenship. So I think long term we're going to see birthright citizenship upheld. They may not have the votes tallied yet, but I suspect they'll find 5.
If we take the case of birthright citizenship out of the equation here, Joe, and just take the result of this decision, is one of the byproducts of this down the road a more coordinated approach to get into every district court at close to the same time to try to get decisions across the country on individual cases? In other words, instead of one district court deciding for everybody, are we going to be tying up district courts all around the country in a coordinated effort to get as many decisions out uniformly as possible by plaintiffs?
Yeah, easier said than done, but I think you're correct. That will happen. It's also been suggested that class actions will now be more in vogue as a means of trying to get nationwide effect on some of these court decisions and important constitutional matters. Let's say, look, it's clear to me that one of the things the Trump administration is going to do down the road here is start issuing executive orders on voting rights. And the various states, there's certain AGs in the blue states, for example, that are going to resist that and run right to the courts, and the red states will not. And so you're going to have a patchwork of federal law regarding voting rights. And so how do you deal with that? Yeah, there'll be some efforts at coordinating. There'll be some efforts to qualify these cases as class actions. But that's a lot of coordination. You were talking about 50 states. You're talking about a lot of litigants, a lot of lawyers. I know one thing, there's going to be lawyers who are busy going forward.
I just Googled it. It says there are 94 federal judicial districts with at least one district court in each state and the District of Columbia. So this would seem to be something that if you are a large law firm, this would be a benefit to you.
A benefit in some ways, but let's not forget that the Trump administration has gone after a lot of these national law firms and have put, they've put down the marker that the administration could take action against you. So some of these national firms who are traditionally engaged in this kind of national litigation, they're going to be hesitant to take up some of these cases. So it'll be interesting to see how that works out.
So if we extrapolate this out into the past, say a civil rights violation, and one of the district courts finds that a particular activity is by definition discriminatory and cannot happen. Didn't that used to have set a precedent for the rest of the nation when a decision like that? I know I'm being unspecific here.
Yeah, it did. Oftentimes in federal litigation, if one district court in one state, say, or one circuit issued an order making a determination of law on a particular issue or subject, that could be cited and was often cited in other district courts across the country. So that's an important aspect of federal practice.
So extrapolating on what Rob was saying with 94 district courts, if you're going to slam all of them at the same time, don't you have to find 94 victims for each of those courts to decide?
Oh, certainly. But let's take voting rights. If an EO comes down from the Trump administration curtailing a certain practice under the Voting Rights Act, let's say, it's easy to make the case that applies to us nationally because we all vote in all 50 states. And birthright citizenship's the same way. We have babies being born of non-residents in every state in this country. So there are certain cases, and in fact, Amy Coney Barrett's opinion does leave a couple small openings there for district courts to still grant nationwide relief in certain cases. And you would think birthright citizenship would be one of those.
Yeah, Joe, and one of the arguments made that this has been nationwide injunction been in practice since the early 1800s, and the argument that Barrett made was you have to have standing and should have standing in each one of the 94. But a counterpoint has been made that if something is constitutionally illegal in one of these 94 districts, it should also apply to the other 93 if it's constitutionally illegal.
Well, sure. If you take this Supreme Court decision to its logical ends here, you could have a baby born in New Jersey considered to be a resident of this country, and a baby born across the line in Pennsylvania not a resident. And I don't know that that's the kind of I would call it chaos that we want to have, where now we're going to be treating these individuals who are born in different states differently in terms of their ability to qualify for federal benefits and all the other things that citizenship grants you. It's an unworkable situation, and I still think there'll be certain cases where federal district courts will be able to issue nationwide injunctions.
See, I think we're burying the lead here. I don't think this case really was ever about the birthright. I think this case was fundamentally about the ability of district courts to shut down an administration's entire strategy, right? So, and Bill, what you're saying that if one judge, if in New Jersey a decision is made, it should affect everywhere. Well, you never know who the judge is. Every president gets to appoint their judges. So you got the liberal judges and you got the conservative judges. You got the constitutionalists, right? You've got for one judge to be able to shut everything down nationwide doesn't seem reasonable to me.
And you're exactly right. And that was the argument, because remember, Biden's was shut down by a Texas judge a few years or so ago when it came to, I think, abortion, one of the abortion issues. And all presidents have been rebelling or against this nationwide injunction. So there were problems with it. Admittedly, there were problems. But I think what the decision made right now presents another suite of problems.
And, Joe, before we run out of time, let's hit that Montgomery County decision that came down, too.
Yeah, very interesting. As you know, Montgomery County schools had course materials that included gay and trans characters in the writings. Some parents sought the ability to have their students opt out of those classes for religious reasons. The school board resisted, saying, hey, we can't have parents opting out anytime they want to, citing religious reasons. It's unworkable in the school system. Well, in the 6-3 decision, the court said that the family's religious beliefs are to be respected and not discriminated against with a school policy that does not allow opt-outs. The opinion was from Justice Alito, who went on to extol the virtues of religious teachings, of course, which he likes to do, and he says how fundamental such teachings are in the parent-child relationship. Contrast that case, however, and this is a comment by me, with the U.S. versus Ferretti case, which is the Tennessee law banning transitional treatment for minors. We know West Virginia has a very similar law in the books. That decision indicates that parents are not allowed, and in states can ban parents from getting treatment for their children who suffer from gender dysphoria. So in the Mahmoud case, the Montgomery County school case, religious beliefs between parent and child are so fundamental to the upbringing of the child. But in U.S. versus Ferretti, where a parent may choose a course of treatment that they feel is in the best interest of the child, the court is saying the state can ban the parent from doing that. So a little bit of tension there between those two cases. And going forward, there's going to be a lot of states now modeling their laws after these decisions. It'll be interesting to see what happens.
Is that really a good comparison, though? Because one is an intellectual exercise about what a child can and cannot learn in school, and the other is about, one would argue, mutilation of a minor.
Well, hold on. I would argue the one is about the medical well-being and health of a child. We know some of these children are suicidal and things of that nature, and maybe that treatment will protect that child. And the other one's about, yes, bringing the child up in terms of religious beliefs. I think both are fundamental in terms of the parent-child relationship. But we have courts that now are deciding that we can legislate in one area but not the other.
If one of these rulings not revisited, how's that going to be resolved in the courts?
Oh, this current Supreme Court does not seem to mind the internal tensions that they create in coming up with some of these decisions, Bill. That much is true.
Okay, a minute left, Joe. There's probably not enough time to get into the Tennessee decision. But otherwise, overall, when you look at the 6 decisions, is there any particular theme that you saw from it?
Well, we saw a breakdown of pretty much 6-3 in terms of the votes. There's a conservative block of justices, and there's the liberal block, and we know one's comprised of 6 and one's comprised of 3, and that breakdown held true in many of these late in the term decisions come from the U.S. Supreme Court. And going forward, I think we will continue to see that happen, though Justice Roberts and Justice Amy Coney Barrett have shown themselves to swing back and forth on occasion. Those 2 justices, in my mind, are really deciding where the direction of this country going forward.
Thank you, Joe. Appreciate your time and research once again, sir. Great job.
Okay, gentlemen, have a good show.
Thank you, Joe.
Take care.